I am what's known as a California licensed professional fiduciary, and I understand that's quite a mouthful and probably not as familiar to most people as it should be, honestly. I work primarily, my business is focused on the aging population, and I specifically, within that population, sort of specialize in what's known as elder orphans. And so this is a uh, very quickly expanding demographic of people that are aging that either never had children or never got married, or perhaps have children but they're geographically dislocated from their adult children, or there may be some other reasons that adult children can't help their aging parents for specific situations that may arise as we all get older. So one of the things that I do is there's two different basic phases in life where someone like me would come into play. And one is when an older person has some sort of change in life event. This can typically be a health related issue, such as a fall, or it can be a cognitive issue, such as a diagnosis of dementia, where mental faculties are starting to decline. But either way, it can arise in a situation where an older person living alone who doesn't have much family or no family nearby that's able to help finds themselves in a predicament of how to take care of their life and how to manage all these things they've been managing independently all of their lives, but perhaps either did or did not make a plan for what happens when they can no longer act on their own behalf in a cogent way. So one of the things to think about is, I always advise it's so much better to think about these things in advance. And I know most people don't want to think about getting older or not being as independent as we once were. But the way I usually talk to my clients is you'd much rather have some say in the choices that are made than being subject to choices by someone you didn't choose, or who's making choices or decisions about your life that maybe wouldn't be your preference. So basically, it's better to have a plan in place and make some decisions about that sooner rather than later, so that you're not subject to decisions being made for you that you would not necessarily want. And what I mean by that is, you know, often, like I'm saying, often there's a crisis that initiates choices that have to be made. So, for example, an elder person living alone who falls and breaks a hip may be hospitalized. And then upon discharge, the discharge planner at the hospital will need to confirm that there's some sort of plan in place at home for the person to return safely home, meaning, that there are, that the house is accessible, that the person can get in and out of the bathroom. How much assistance do they need getting in and out of the bathroom? Are there stairs? Do we need a chairlift? I mean, so there's physical modifications that might need to be considered, as well as caregiving assistance that may need to be considered before you can even go home. And, many people, this doesn't occur to them until this situation arises where the hospital discharge planner is saying, well, you can't go home until all of these things are arranged. And otherwise, the option is to be in sort of a limbo and skilled nursing until those things can be put in play in your home. And, especially now, and what is happening with COVID, and what has been happening, just, I think a light has kind of been shed on the stress on skilled nursing facilities and the challenges they face in staffing and so forth. So I think most people would prefer to spend as little time in skilled nursing as possible. They would rather go home. And in order to go home, there needs to be a plan in place for all of these things, both physical, caregiving, support for finances, who's paying the bills, that sort of thing. So typically that's when I come into play. So whether somebody's already identified me as a person that would be activated, so to speak, in this circumstance, or whether they're in that situation and they have to identify somebody that can help them with these things, that's often when I'm introduced into the situation. So some of the things I do is I can serve as both a financial power of attorney and a healthcare power of attorney. And the differences between those two things is, the financial power of attorney is somebody who is going to pay bills for you, or is going to oversee your investments, or oversee your property management, or if you own a business, helping maintain your business while you're ill. The healthcare power of attorney is, you may have heard of an advanced healthcare directive. So usually it's somebody that's named as an agent who is not only someone that makes decisions for you, but also is an advocate for you with your medical team. So if you're not able to make your own medical decisions due to a temporary incapacity, say when you're under anesthesia, or a longer term incapacities such as cognitive issues due to dementia, you need somebody that not only can carry out what your wishes are in terms of your healthcare, but also advocates for your healthcare. So someone that's, actively meeting with your doctors and your care team to decide what the best plan is for your care physically. So those are two different roles. Those can be two different people, or they can be the same person. So sometimes I serve in both of those roles. Sometimes I serve in one of those roles for various people. But what I find is, often people really haven't thought about this until they need it. So what I'll recommend again is to think about this before you need it, and to also think about, who you might name as a financial power of attorney, whether they actually have the availability to do it, and whether they have the skill set to do it. So you may have a trusted family member or a neighbor or a friend, and you trust them implicitly, and you want them to do this for you, but they may have their own obligations and responsibilities where they wouldn't be able to spend the amount of time needed to really step in and take care of these things for you. And so that's sometimes why a person would choose someone like me to act on their behalf, rather than burdening a friend or family member that may not have the bandwidth to take that on at any given moment due to their own responsibilities, or someone that is truly an elder orphan that doesn't have anyone that they can identify to fill that role. And same with the healthcare power of attorney is, I can serve in that role if there's no one identified in your social network that has the skill set or the bandwidth to make those kind of decisions on your behalf, or if you don't have someone to make those decisions that you can identify, I'm someone that can be engaged to do those sorts of things for you. So that's one facet or one period of time where I would be called in to serve, and that's during the lifetime of someone who engages me to act as their power of attorney, whether for finances or healthcare. The other role that I play is after death, so administering someone's estate. So carrying out the wishes of someone's trust estate administration, or their will, or whatever estate plan they have designated. I'm someone that can be appointed to serve in that role to make sure that the wishes are carried out according to whatever plan you make. And some of the things to think about with that are the same thing. You may either have no one that you can identify that would be able to serve in that role, or you maybe have somebody that you've identified, but at the time they're called upon, they really don't have the availability to fully administer the trust, or they're not geographically close. So you might I often run into this where you name a sibling, but they live in Florida, and you have several real properties in California, and the sibling in Florida isn't able to travel and really deal appropriately with real property or the liquidation of the personal property inside the homes, because they are so geographically far away. It becomes a hurdle for them. So I'm often engaged for dealing with trust administrations, or as a executor or an administrator in probate if there was no estate plan made prior to death. Some other things that I always bring up to think about that people don't often think about are, and I'm an animal person, an animal lover, and I have pets, and to really think about a plan for your pets as well. And that if you're living alone and you're older, that you have some plan in place that if you're hospitalized, there is someone that is notified and knows that you have a pet at home that needs to be taken care of. Unfortunately, far too often I have run into situations where someone was hospitalized and they had a pet at home, and nobody knew that there was a pet at home until it was too late. So these are the sorts of things that we don't always think about as being associated with our own crises, right? That they can extend to our pets as well, that we need a plan for our pets as well, not only when we're living and have some sort of health crisis, but after we die, what happens to our pets, and who's taking care of our pets, and do we have a plan for making sure somebody knows that there's a pet in the home if something were to happen to you. So, I am not an island unto myself. I do this work, but I work in a team environment. So I take a team approach. I often work with, estate planning attorneys, CPAs, financial advisors, care managers, caregiving agencies, various assisted living facilities, independent living facilities. And so part of what I have to offer is that I am connected to a lot of resources and a lot of up-to-date resources about options for not only housing, but care, as well as financial management and planning. So that if there is a multi-layered need, there is a team of people that can help when called upon. And I'm going to just pause because I feel like I've been talking for a long time. If anybody has a question, I'm happy to answer questions.
I have a question for you.
Mm-hmm.
I recently came across a homeowner situation for a remodel that has an attorney in fact. What is an attorney in fact compared to these other attorney options?
So an attorney in fact is a power of attorney. So basically the power of attorney appoints an attorney in fact who is their agent that acts for them. So, and that can be, there's several different types. So it can be limited to where it only comes into play when needed, or it can be effective right away, or it can be effective once you lose capacity and cannot are unable to make decisions for yourself. So power of attorney, same thing as attorney in fact.
Thank you.
Mm-hmm. So if you have a executor or a successor trustee and stuff, and you don't arbitrate if they don't get along or something like that, that's not part of your bailiwick. But if they asked you to come in and help them settle an estate, would that be an appropriate role for you? So if you already have a.
So typically I would already be named, so I would be acting as either the successor trustee or the executor.
Okay.
Or if there's a currently named executor or trustee that feels that they cannot complete the duties, they can resign and name me. Usually okay. that also happens. So, but in terms of, now that you brought up conflict, as I think everybody can understand, especially when somebody passes away or somebody is sick, or somebody has been diagnosed with, some sort of progressive disease. It can be a very stressful time for families. And often that's another reason that someone would choose me to serve, is if they feel that there will be conflict within the family and that it would be hard for a family member to remain neutral in their decisions, or that they wouldn't be perceived as being neutral even if they were. So, this happens a lot with multiple siblings. So, the more people, more problems, right? It's hard to get consensus from 4 or 5 siblings as to the way things should be distributed, for example. And it can be hard for siblings to think that the way that things are being distributed is fair if one of the siblings is in charge of making those decisions. So often families will look to me to serve as sort of a neutral party in making those decisions, so that it takes out of the equation that I have, any dog in the fight, so to speak, and that I can sort of mediate between family members to reach or achieve a fair solution.
Thank you for your response, but does that have to be like court confirmed, or can you just be asked by the successor trustees to come in and help settle something?
So it depends. So the trust instrument, if we're talking about a trust, the trust lays out the terms of the trust. So frequently, the majority of the time, the trust lays out a process for the current serving trustee to resign and appoint someone. Sometimes the trust will state it has to be a court appointment. So it depends on what the trust document itself dictates. And I've been appointed both ways, or sometimes the document says nothing and there's argument about who should serve, and then the court has to become involved and I get appointed that way by default. But I think what most people want to avoid is court. So essentially, most people want to create a trust or an estate plan that has a way around court, because the whole reason you're creating an estate plan is to avoid the cost and expense and the public nature of court proceedings. So I would say, it's a good thing to review your estate plan every few years with your attorney, just to make sure that you're aware of what happens if somebody can't serve, that there's a mechanism to appoint somebody else, that you're still in agreement with the person that's named, or that they're still alive and healthy. I mean, it's good to just review every few years to make sure that you're comfortable with who is named to act in your trust, and that you're reviewing that at least, every 3 to 5 years with your attorney to make sure it still makes sense.
I have a quick question for you. You have a law degree,
Mm-hmm.
and I believe that's not a common thing, that most professional fiduciaries don't have a law degree. Does that, having your degree, does that allow you to address a wider spectrum of problems for people? Because it sounds like you might be able to fill both shoes,
So I'll say this: to avoid conflict, I would never serve as both a fiduciary and as a legal advisor, so to speak. So I am committed to serving as a fiduciary predominantly, but what I will say is I have a particular set of skills and experiences, because I've studied the law, that I'm familiar with the law. Maybe that would be a more specialized area that I have understanding for. And then I also have some social work background. So for me, this work has been kind of a marriage of social work and law. Other fiduciaries have completely different bents. So there are different people that come to this work through different paths. So there are some that come through a therapeutic path, so they're LCSWs. There's some that come through a medical background. And so there's lots of room for specialization within serving as a fiduciary. And, I would advise, if you're thinking about engaging a fiduciary to serve in your estate plan, that you find one that has the particular specializations you're concerned with or most important to you for your circumstance.
If we want to connect you with someone, what is the best way to do it? Is it through your LinkedIn profile?
Yeah, you can certainly connect through my LinkedIn profile, which is my name, Minna Fernan, Fernan, professional fiduciary. My email address is also a good way to contact me, which is my first name, Minna, Minna, trustee, TRUSTEE @gmail.com.
Thank you.
You're welcome. If there's no other questions, I just want to thank you all again for allowing me to present. I'm sorry I didn't have time to make any visuals that that you just had to hear me speak for a while. But I'm always happy to share information if you want to pick my brain, or if something comes up, or if you have a client or someone else in your life that you think might benefit from at least considering a private fiduciary versus a friend or family member in some of these roles. I'm always happy to talk to people.